Assalamualaikum and greetings to all. We are from Group 6 RAS2035B. We present to you Chapter 6.5, Other Acts Related to Safety and Health, including Employment Act 1955, Employees Social Security Act 1969, and Fire Services Act 1988. My name is Hamida binti Shabri, student ID 2019602528. I will present to you regarding the Employment Act 1955. Employment Act 1955 is the main legislation on labor matters in Malaysia. The aims of the Employment Act is to deal only with provisions relating to safety, health, and welfare. It is a provision for regulations relating to the work, and it protects the rights of the employee employed. This means that this Employment Act talks about the right of the employee, where the employee is entitled to maternity leave, annual leave, sick leave, overtime pay, and more. Those who are covered under this Act are all employees with earning of less than 2,000 ringgit per month, and all manual workers irrespective for their earning. If you are a foreign worker legally employed in Malaysia, you are also covered under Employment Act 1955. However, this act is only for private sector, not for government sector. If any of this right is not given by the employer to the employee, then the employee can lodge a report to the Labour Office. Terms and interpretation. Employer is any person who has entered contract of service to employ any other persons as an employee. Place of employment is any place work is carried out by the employee for the employer. Contractor is a person who contracts with principal work undertaken by the principal. And lastly, contract of service is any written or verbal, expressed or implied, where one person agrees to employ another and the other agrees. Now we come to the employment of women. Section 34, prohibition of night work. No female employee shall work in any industrial or agricultural activities between 10 p.m. to 5 a.m. unless they had an 11 consecutive hours free from work, which means rest. This means female employees shall not work at midnight. Because of what? Of course, it is dangerous for them to work at these hours. However, if the Director General of Labour give the exemption to them, then they are allowed to work during this hour. That's why you can see some companies have female employee work at night, because some companies, some factory needs to keep on running the machineries and so on. This also means that a female employee can work plus overtime to approximately 12 hours. And then rest must be given to them. Next, Section 35. No female employee shall be employed in any underground working, such as work operations are carried out to extract any substance from below surface of the earth and to access or egress by means of shaft or natural caves. But sometimes you ask, if so, then why there are some females working underground? They can work underground because they are not employee. They are professional with salary more than 2,000 ringgit, such as engineers. So they are not governed by this Employment Act 1955. Then Section 36, prohibition of employment by minister. The minister may prohibit or permit the employment of female employees in such circumstances or under such conditions. Next, maternity protection. Section 37, length of eligible period and entitlement to maternity allowance. Every female employee is entitled to maternity leave of not less than 60 consecutive days. This eligible period for each confinement. She also should receive maternity allowance from the employer. So when a female employee get pregnant and safely delivered her baby, then the employer need to pay them for maternity allowance. But it is considered that she has received the maternity allowance if her monthly wages are being paid continuously during the maternity leave. So for the 2 months, the employer doesn't need to pay the maternity allowance if they paid the wages in these 2 months. But can or cannot employer give benefit more than what is provided by the Employment Act? Of course they can. The more benefit is much more better for the employee, but less than that, less than what is given by the Act, it is not allowed. That is wrong under the law, and that will give the entitlement for the employee to lodge reports to the Labour Office. Rest days, hours of work, holidays, and other conditions of service. Section 59, parenthesis 1, rest day. Employee is allowed for 1 rest day each week. And when they are doing shift work, then employee is allowed for 1 rest day after 30 hours of continuous work. This provision is not only for female but also for male employees. The employee is entitled for 1 whole day of rest. It doesn't mean rest on weekend. It can be on Monday, Tuesday, or Friday, depending on the industry. Some industry is not appropriate to give weekend as holiday. For example, hospital, hotel. Under a situation, as long as there is 1 whole day of rest, then it is okay. Section 68, parenthesis 1, hours of work stated that employee shall not work more than 5 consecutive hours without about 30 minutes of rest, more than 8 hours per day, more than 10 hours of spread over period per day, and more than 48 hours per week. While in section 60A, parenthesis 2, hours of work, employer may require an employee to exceed the limit of hours and to work on a rest day in the case of accident actual or threaten the place of work, work essential to the life of the community, work essential for the defense or security of Malaysia, urgent work on machinery or plant, interruption of work that is impossible to foresee, work essential to the economy of Malaysia, and any essential service as defined in the Industrial Relations Act 1967. Section 60F, parenthesis 1, sick leave. How long actually an employee is entitled for a sick leave? An employee shall be entitled to be paid sick leave of total 14 days per year for them who in service of less than 2 years, and then total of 18 days per year for 2 to 5 years of employment, total of 22 days per year for more than 5 years of employment, and total of 60 days per year if hospitalized. Employee just cannot simply take a sick leave, simply produce a medical certificate, the MC, because Employment Act has provided that sick leave depending on how long the employee is in service. This is called loyalty. Then what happens if the employee need more than the given sick leave? Then the employee have to go under hospitalization. For example, if you had an accident, then you broke your arm, you are being hospitalized, then you are entitled for 60 days of sick leave. So to be entitled for the sick leave, the employee must inform the employer and provide medical certificate from legal or certified medical practitioner. Lastly, the regulations that apply this Employment Act 1955 are Employment Regulations 1957, Employment Limitation of Overtime Work Regulations 1980, Employment minimum rate of maternity allowance, regulations 1976. Employment termination and layoff benefits, regulations 1980. Employment of women, shift workers, regulation 1970. Employment of women, female conductors, regulations 1958. Employment procedures, reciprocal provisions, regulations 1957. And employment limitations of power officers, regulations 1993.
Assalamualaikum, my name is Nabila Liana and I'm going to continue this presentation with the Employees Social Security Act 1969. First, we are going to talk about social security concept. Employees have to be protected by social insurance to reduce the sufferings and to provide financial guarantees and protection to the family. Accidents can result in disablement or death, and occupational disease affect employees as well as dependents. Employees are exposed to various contingencies causing hardships. Next, we will continue on Social Security Organization or SOCSO, which is the setup to implement, administer, and enforce the Employee Social Security Act 1969, which was amended in 1992. Next is the objective. The Employee Social Security Act 1969 aims to provide social security in certain contingencies by making provisions for certain matters relating to it. The scope and applications for this act is applied to all industries having more or equal to 1 employees according to Section 3. All employees where the act applies must be insured according to Section 5, and industries with any business, trade, undertaking, manufacture, and etc. according to Section 210. The main provision for this act is insurability and contributions, benefits, administration, finance and audit, adjudication of disputes and claims, penalties, and miscellaneous. As for the schemes and benefits, the Employment Injury Scheme provides an employee with protection and coverage for accidents at work, traveling, residence, and workplace where he takes his meals during authorized breaks, or connected to his job, but not during a stoppage or a deviation from the route. And lastly, occupational disease. That is all from me, and I will pass these presentations to my other group members. Thank you.
Assalamualaikum, I'm Hanifah. I will continue the presentation for Employee Social Security Act 1969. Now, we concentrate to the benefits. There are a lot of benefits for the insured person and their dependents. Now, I will explain in detail about the benefits. First is invalidity pensions, the payments to insured person in case of invalidity certified by an appointed medical board. Second, disablement benefits, the payment to insured person suffering disablement from sustained employment injury certified by an authority. And third, dependent benefits, the payment to the dependent of insured person who dies from sustained employment injury. Next, we proceed to the funeral benefits, payment for funeral benefit or expense to specified person on the death of an insured person resulting from sustained employment injury. And next, constant attendance allowance, periodical payments to the insured person who is disabled as to constantly required to attendance of another person. For medical benefits, medical treatment and attendance for insured person who suffering disabled from sustained employment injury. And lastly, survivor pensions, periodical payment to a dependent of insured person who dies and has completed a full or reduced qualifying period for survivor pensions. Disable benefit part consists of two types, that is temporary and permanent. For temporary, cash benefit paid when certified by a doctor to be unfit for work or not less than 4 days, including the days of the accidents. And for permanence, the benefit shall be payable for a limited period or for life. If an employee employed in an occupation described in the 5th schedule develop any disease or injury shown in the schedule to be related to the occupation and within 60 months after retirement or quit, it is considered as employment injury. For medical benefits, when employee meets with an accident or suffer from any occupational disease, he is entitled to treatment at the SOSO-Penal clinics or any government hospital or clinics, and SOSO will settle his medical bill. If treatment in a SOSO-Penal clinic, he must continue at the same clinic until he recovers, unless referred to a government hospital. For serious injury, treatment at the nearest government hospital and eligible for second-class ward treatment. Lastly, specialist treatment will also be provided at the government hospital. SOSO promote measures with existing institutions for the improvement of health, safety, and welfare of the insured, provision of artificial limbs, and opportunity for employment. SOSO also cooperate with the existing institution, provide rehabilitations and re-employment of insured persons who have been disabled or injured. Vocational and physical rehabilitation free for those suffering from permanent disability. Physical rehab, including physiotherapy, reconstructive surgery, artificial limbs, and other prosthetic appliances, wheelchair, hearing aid, spectacle, calipers, and including their repair and replacement. Last, for my part, the penalty. Punishment of false informations made or caused to be made any false statement or false representation or make in writing or sign any declaration, form, report, certifications, or other document required by the Act or regulation is untrue or incorrect. Punishment for failure to pay contributions for both penalty is 2-year jail or 10,000 fine or both.
Assalamualaikum, my name is Nurafida binti Raza and I will be explaining the Fire Services Act in 1988. Let us begin with what is Fire Services Act 1988. It is an act to make necessary provision for the effective and efficient functioning of the fire and rescue department, for the protection of persons and property from the fire risk or emergency, and for purposes connected therewith. As mentioned before, the Fire Services Act 1988 is imposed to legislate the necessary provision for the effective and efficient of the fire service department and also the protection of persons, property from risk of fire. There are 9 parts involved in the arrangement of regulation. First is the preliminary, second is the administrations, third is the abatement of the fire hazard, fourth is the water and fire hydrant, 5 is the fire certificate, 6 is the enforcement, 7 is inquiries into fires, 8 is welfare fund, and 9 is the miscellaneous. The first part of the regulation is preliminary. This act shall come into operation on a date to be appointed by the minister by notification in the Gazette, and different dates may be appointed for the coming into operation of this act or of different provision of this act in Peninsular Malaysia, Sabah and Sarawak respectively. This act includes regulation and other subsidiary legislation made under this act, such as fire hazard. Fire hazard means any unlawful alteration to any building such as might render escape from any part thereof in the event of a fire materially more difficult or less easy than it would be if the alteration had not been made. The overcrowding of any place of public entertainment or public gatherings such as might render escape from any part thereof in the event of a fire difficulty. Lastly, any removal or absence from any building of any firefighting equipment or fire safety installation that is required by law to be provided in the building. Next is the firefighting equipment or fire safety installation, which means any equipment or installation for extinguishing, fighting, preventing, or limiting a fire, giving warning for a fire, providing access to any premises or places or to any part thereof for the purpose of extinguishing, fighting, preventing, or limiting a fire, providing emergency power supply in the event of normal power failure, providing emergency lighting for the purpose of escape from building, giving direction towards an escape route or place of refuge, and lastly is controlling the spread of smoke resulting from fire. Lastly, under part 1 is the premises. It means that it includes massages, houses, building, or part of a building, lands, tenements, easements, and hereditaments of any tenant, whether open or enclosed, whether built or not, whether public or private, and whether maintained or not under statutory authority. Next, let us move on to the part 2, which is administration. It is stipulate the provision pertaining to the methods of administration of the Fire Services Department. The provision includes the Fire Services Department and its officer. There shall be a Fire and Rescue Department of Federation. There shall be a Director General of Fire and Rescue and such number of Deputy Directors General of Fire and Rescue, Directors of Fire and Rescue, and other senior fire officers and fire officers such as may be necessary for the effective and efficient functioning of the department. Next, the provision also include appointment of auxiliary fire officer, which means the Director General may, with the concurrence of the Minister, appoint such number of auxiliary fire officers for each state on such term and condition may be prescribed. The third one included in the provision is the duties of the Fire Services Department. Next is the uniform and identification card. Next is also, lastly, is the exercise of powers and performance of duty. In part 2, administration also highlight the duties of the Fire Services Department. The duties of the Fire and Rescue Department shall include taking the lawful measure for extinguishing, fighting, preventing, and controlling fire, protecting life and property in the event of a fire, securing the provision, maintenance, and proper regulation of fire escape, and securing the provision of adequate means of exit in the event of fire from all designated premises. Next, the duty of the Fire and Rescue Department is the making of investigation into the case, into the cause, origin, and circumstances of fire. And lastly, the duties of the Fire and Rescue Department is performing humanitarian service, include the protection of life and property in any community. To make it easy to understand, here is the duties of the Fire Services Department. The third part in the regulations arrangement is the abatement of fire hazard. This part stipulates the provision pertaining to the method abating fire hazard and the power of the Director General of the Fire Services Department. Among the provisions are fire hazard abatement notice, the power of Director General to abate fire hazard in vacant or unoccupied premises, offence of failing to comply with the fire hazard abatement notice, closing order, the power of fire services officer in the event of fire, and also appeals. In the fire hazard abatement notice, the Director General, if satisfied of the existence in any premises of any fire hazard, may serve on the person by reason of whose act, default, or sufferance the fire hazard arose or continue, if he is the occupier of the premises at the time the notice is to be served. A fire hazard abatement notice in Form A in the first schedule, requiring him to abate the fire hazard within the period specified in the notice, and to do all such things as may be necessary for the purpose, and the notice may, if the Director General thinks it's fit, specify any work to be executed for the purpose. Here are the charts that includes in the abatement of fire hazard. Next, let us proceed to part 4 of the arrangement of regulation, which is water and fire hydrants. It stipulates the provisions pertaining pertaining to the water and fire hydrants. It includes storage of water in premises for firefighting purposes. For explanation, it is the Director General may, for the purpose of ensuring that there is adequate storage of water at suitable location on the premises, issues such as direction to any person in control or the owner of such premises to provide facilities and water supply for the firefighting purpose. Next, it includes notice of work affecting the fire hydrant, which explained is no person or other than the water authority and its agent shall commence or carry out or authorize or direct the commencement or carrying out of any work that affect any fire hydrants or the flow of water to it unless written notice of the proposals or intention to carry out such work had been given by him to the appropriate state director at least 7 days before works are commenced. Next is the duty of the water authority to notify the state director of any action affecting the flow of water to a fire hydrant. Where a water authority decides to take actions or do any act or carry out any work that will or is likely to reduce or stop the flow of water to any fire hydrant, it shall be the duty of the water authority to notify the appropriate state director in the writing of such decision as soon as possible after it is made. Next is the power to fix the fire hydrant location plates. Upon giving 7 days notice in writing to the owner of any property situated in the vicinity of a fire hydrant, the Director General may cause a plate indicating the location of the fire hydrant to be fixed to such part of the property as in the opinion of the Director General is best suited to indicate such location. Lastly is the concealment and misuse of fire hydrant. Any person who cover up, encloses or conceal any fire hydrant so as to render its location difficult to ascertain or tampers with any fire hydrant or uses a fire hydrant other than for fighting purposes shall be guilty of an offense. For a better understanding and easy explanation, here is the flow chart of the water and fire hydrant provision. The fifth part of the arrangement of regulation is the fire certificate. It stipulates the provision pertaining to the fire certificates. In fire certificate involve power of Director General to determine and design particular uses, size or location of premises, where the Director General may, by order published in the Gazette, determine and design particular uses, size or location of premises for the purpose of issuance of a fire certificate under this Act. It also involves fire safety organization in designated premises, where the owner, occupier, or persons having the overall management of the designated premise shall establish a fire safety organization. Next is the requirement of fire certificate. Every designated premises shall require a fire certificate. A fire certificate shall be renewable annually. Next, it also includes application for an issue of fire certificate, where an application of a fire certificate in respect of any designated permit shall be made to the Director General in the prescribed form. On receipt of any application of fire certificate in respect of any designated premises, the Director General may require the applicant within a specified time to furnish him with such plan of the premises and any other relevant particular as he may specify. If the application failed to furnish the requirement plans and the relevant particulars within the specified time, the application shall be deemed to have been withdrawn. Next is the form of fire certificate. Every fire certificate issued in respect of designated premises shall be in the prescribed form. Next is the prescribing of fees for the issue of fire certificate. The Director General may prescribe the fees payable for the issue of a fire certificate and the charges for the inspection of any designated premises for which the certificate is issued. Lastly is the changes of condition affecting adequacy of firefighting equipment or fire safety installation. So long as the fire certificate is in force in respect of any premises, the Director General may cause any part of the relevant premises to be inspected at any reasonable time for the purpose of ascertaining whether there has been a change of conditions by reason of which the firefighting equipment or fire safety installation have become inadequate in relation to any use of the premise covered by the certificate. The fifth part of the arrangement of regulation is the fire certificate. This part stipulates the provision pertaining to the fire certificate as follows. The power of the Director General to determine and design the particular uses, size, or location premises for the purpose of issuance of a fire certificate under the Act. Next is the requirement of the fire certificate and fees for the issuance of the fire certificate. Thirdly is the change of condition affecting adequacy of life safety facilities. Next is the offence in relation to the fire certificates. Next is right to appeal, and lastly is the court's power and the power of the Director General. That is all from me, and I'll pass to my next groupmate, which is Nur Shamimi, to explain the rest of the arrangement of regulation.
My name is Nur Shamimi binti Muhammad Fauzi. Student ID is 2019-619-312. Today I will present about Fire Services Act 1988, continuing from Part 6 to Part 9, Schedules and Regulation. Part 6, which is Enforcement. And this part including power to enter, arrest without warrant, investigation, presence of witnesses, inspection of witnesses, and prosecution. Firstly, we must know that this enforcement shall be the duty of the Director General to enforce the provision of this Act. Power of entry. An authorized officer, together with other persons, may enter any premises if necessary for the purpose of, firstly, obtaining such information concerning the premises as if required for firefighting purpose, and secondly, ascertaining whether there exists any fire hazard in the premise or affecting the premise. And we must remember that no private dwelling shall be entered between the hours of 7 in the evening to 7 in the morning. Then, before entering any premises, an authorized officer shall display to the occupant thereof the written authorization of the Director General. Otherwise, you cannot enter the premise. And lastly, an authorized officer shall leave the premises vacant or unoccupied when he found them to be at the time of the entry, when he has entered the premise to secure against trespassers. Power to arrest without warrant. Any authorized officer may arrest any person without warrant when he found that person committing any offence under Section 47. And the officer can reasonably suspect that person to have committed any other offence under this Act if the person refuses to furnish his name, his address, or furnish an address out of Malaysia. And the officer making the arrest shall comply with Section 28 of the Criminal Procedure Code Act 593 as if he were a police officer. Power of investigation. Any authorized officer shall have the power to investigate the commission of any offence under this Act, and every person that required by an authorized officer should give information, produce any document or the other article relating to the commission of such offence. Power to require attendance of witnesses. Firstly, an authorized officer making an investigation under Section 41 may order in writing require the attendance of the person who appears to be related with the circumstances of the case, and that person shall enter as so required. If any such person fail to attend, The officer may report such failure to a magistrate to issue a warrant to secure the attendance of such person. The most important part of the enforcement is the examination of the witnesses. Firstly, an authorized officer making an investigation under Section 41 may examine orally any person supposed to be acquainted with the facts and circumstances of the case, and such person shall be bound to answer all the questions relating to the case put to him by the officer. Then, a person making a statement under this section shall be legally bound to state the truth. The last part of the enforcement is conduct of prosecution. Every authorized officer shall have the authority to appear in court and conduct any prosecution in respect of any offence under this Act. Next, we will discuss Part 7, which is inquiries into fires. Firstly, Fire Inquiry Commission. The Minister may appoint any person to form a commission and to hold an inquiry into the cause and circumstances of any fire, and the basis of the finding in the inquiry, including the steps to be taken to prevent the outbreak and to improve the method of fighting or extinguishing the fires. The second part is taking possession of premises or other property destroyed by fire. First, any premises are rendered uninhabitable as a result of the fire, and the Director General may take possession of the premises or any other property destroyed by the fire at any time within 7 days after the occurrence of the fire, and they may retain possession of such premises or things for a period not exceeding 30 days. However, the Director General may continue to retain possession of the premises until the completion of the inquiry if the person appointed to hold inquiry under Section 45. Next is Part 8, which is Welfare Fund. First, we discuss about establishment of the fund. Firstly, the established fund should be known as the Fire Services Department Welfare Fund, which shall be operated as a trust account within the Federal Consolidated Fund. Secondly, the fund shall consist of all fines inflicted upon fire officers in any disciplinary proceeding. Next is Fire Services Department Welfare Fund Committee. They shall establish a Fire Services Department Welfare Fund Committee which have the control of the fund, and the committee shall consist of the following members, which is the Director General as the chairman, and 2 senior fire officers to be appointed by the Minister. Next is money for fund to be raised only with consent. First, we must take note that no person shall carry on activity to raise monies for the fund without the prior written consent of the committee. If you do so, you shall be guilty of an offence. Lastly is administration and application of the fund. Firstly, the fund shall be administered in accordance with regulation made under this Welfare Fund Act, and it can be applied in recompensing fire officers for extra or special service rendered by them, and the purpose of this fund is to procuring comforts or other benefits which are not chargeable to the public revenue. Lastly, we will discuss about the last part of the Fire Services Act 1988, which is Part 9, Miscellaneous, and this part consists of special duty and expenses thereof, offence, general penalty, compounding of the offences, power to apply act to vessel and movable structure, power to make regulation by the Minister, and lastly is repeal. Okay, the first offence that we will discuss is interfering with fire officer in execution of his duty. Any person who willfully abuse, disturb, hinders, obstruct, or interfere with any fire officer acting in the execution of his duty shall be guilty of an offence and can be liable to a fine not exceeding 50,000 ringgit or imprisonment not exceeding 5 years or both. The second offence is failure to comply with direction. Under this Act, a person who failed to comply with any direction given by an authorized officer when he carry out his duty shall be guilty of an offence. The third offence is the falsification of document or false statement. We must know that Any person with intent to deceive or forges a fire certificate or give any information that he knows to be false in a particular material will also be guilty of an offence. And the last offence is giving of a false report of fire. And a person who gives a false report of fire shall be guilty of an offence and be liable to a fine not exceeding 20,000 ringgit or imprisonment with not exceeding 3 years or both. The third part of the miscellaneous is general penalty. Any person guilty of an offence under this act can be fined not exceeding 5,000 ringgit or to imprisonment not exceeding 3 years or both. Compounding of the offences. Firstly, the Director General or any fire officer who was authorized by him in writing the statement may compound any suspect who has committed such offence by a sum of money not exceeding 500 ringgit. Then, once the payment was done by the suspect, he shall be released and no further proceeding shall be taken against such person. Lastly, I will discuss about the Power to Apply Act to Vessel and Movable Structure and also repeal. For the Power to Apply Act to Vessel and Movable Structure, the provision of this Act shall apply to any movable structure or vessel remaining on dry land for such periods or in such circumstances as may be prescribed. And for the repeal, the one who will repeal is the Part X of the Local Government Act 1976 and the Fire Service Enactment of the State of Sabah. Next, I will present about the schedule of the Fire Services Act 1988. There are two schedules under this act, and firstly is the first schedule. It is about the fire hazard abatement notice, and the notice is to show cause, closing order, prohibitory order, and other order to cease activity. And for the second schedule, it is about the rank of fire officers such as commissioner, deputy commissioner, fireman, and rank of auxiliary fire officer. Lastly is regulation. There are 4 regulations enacted under the Fire Services Act 1988. Firstly, Fire Services Regulation 1996, which is about the fee of pusat latihan bom. Secondly, Fire Services Regulation 1997, which is about the Fire Services Department Welfare Fund. Thirdly, Fire Services Regulation 2000, which is about the compounding of the offences. And lastly is the Fire Service Regulation 2001, which is about the fire certificate.